Okay, we're not going to talk about NAR and IAR and MIBOR, mainly because we're talking a lot about IAR today. And I want to try to get through these forms changes and just kind of highlight them for you. Now, you should have received a communication from the Indiana Association of Realtors that spells out these changes, and they sent them out at the end of 2023. So these have been out for a while, but the new forms weren't available, of course, until 2024. So at any rate, we're going to start with a purchase agreement, and I just highlighted some changes that they've made. So they added this language right here on lines 27 through 29. Buyers should verify and rely upon buyer's own determination of total square footage, land, room dimensions, or community amenities if material, and releases the seller, the listing and selling brokers, and all licensees associated with brokers from any and all liability relating to such determination. And I think that this is probably in response to the changes in the ANSI changes to the appraisal process and the way they measure rooms. And there can be a lot of different square footage and room sizes bouncing around out there. And it's hard to determine what the actual room sizes are. And so this basically just says that the buyer needs to rely on their own determination, not what the MLS says or the BLC, not what the agent says. It's they should determine that. So if they're
Good
concerned
question.
about room sizes, they should bring along a tape measure and measure them.
That's the room sizes. What about the square footage of the house? We don't know how to measure that.
Again, the total square footage, because again, that could be measured different ways by different appraisals. And so all of that, the determination of total square footage, land, room dimensions, et cetera, that's up to the buyer to determine on their own. Okay.
How do they do it?
You know, total square footage as determined by an appraiser can be dramatically different than total square footage as determined by the assessor, is a good example. And a lot of times you will see the assessor square footage listed on a listing because that's the only source that the listing agent has for square footage, but that could be different than what the appraisal says. And so this is basically telling the buyer, hey, you know, this square footage could be different. You need to measure on your own to determine, you know, what the square footage is. So we just need to be aware of that. And again, these ANSI changes with determination of square footage will also affect appraisals of values and things of that sort. So we talked about that in the past, about the impact of those. And you know, it is what it is. Appraisers have to follow the guidelines that they're given, even if it means now that an appraisal done more recently and an appraisal done 2 years ago on the same house could show different square footage.
Yeah, I understand that part, and I lived that last week. But I had a representing the buyer, and we have like 300 square foot difference.
Yeah.
But how we measure? Because we don't know how to measure that. I can measure a couple of rooms. I can measure all the rooms, but I don't know what is the square footage.
We don't.
Okay.
That's just it. We don't.
So we tell the buyer, you know, this is what it is, and we're gonna go by the appraiser, because I don't know how to measure that. We're not trained for that.
What you want to do is, when you're talking about square footage, is look at what the listing agent referenced as square footage, and say this is what the assessor says there are square footage in this house. It could be different than that on an appraisal.
I got it. I understand what you're
And you
saying.
just need to let them know that depending on who's measuring, there could be a difference in square footage. That way they can't come back on you later on when the appraisal comes in and it shows a different square footage than the assessor, which was listed in the BLC.
Because when we represented a buyer, in that case, for example, I said, you're doing a great deal. You know, for 14, what was 265, you're buying a house. This over, the price is amazing. So don't miss that. When we did the appraisal, that was 350 square foot less. So the appraiser said that was 243.
Yeah.
The 265. So look at that. And now the square footage went up to being 193 or 190 to 216. So he wasn't buying amazingly now. So, and we go by what we see in the BLC. So look, it's amazing. I see the numbers, but we need to say, if the numbers are right, you're doing great.
Yes.
I don't have the way.
And the thing that it makes it even more important than ever to not go by price per square foot.
How do we do it? It's whatever.
Well, you do it just like you do any, if you're trying to determine market value, you have to look at comparable properties. And this is where it is complicated everybody's, it complicates things for appraisers too. Okay. So let's say that you're trying to do a comparable property and you're making adjustments for square footage. And you have one house that the square footage that is in the BLC, the only square footage that you may have access to is an appraised square footage, and it shows X number of square feet. The house next door, which is the exact same house, quoted assessor square footage, and it's different. And now those comps are different in square footage. So it is what it is. All we can do is our best job and our best estimate of market value in a neighborhood. It's not a science, it's an art. And we need to make sure that we let our buyers know that that's the case. It's, we can give them our best estimate of market value. And, but we can't do really more than that. Okay. Then the next change, any other questions on that square footage?
No.
Okay. The next change is down here on line 53 and 54. If escrow agent is anyone other than a broker, the 60-day letter release process will not be available. And it discusses that, that we, as a broker, we have the ability to send out a letter to both parties saying that within 60 days up here, that if somebody doesn't litigate within 60 days of the mailing of the letter, that the broker may release the earnest money to a party identified in the letter. Okay, real estate agents are the only ones who can do that. If the earnest money is held by a title company, that is not available to a title company. It's only available to a licensed real estate agent, or broker. Just as an FYI, we've talked about this before when people started having earnest money held by title companies. Just beware that the 60-day letter is not available if the title company is holding. Nothing on that. Okay. Let's see.
Say that again. The 60 days letter is not available for who?
It's not available. Okay, if you have a mutual, if you have a buyer and a seller, they don't go through with the purchase and they don't agree with the release of the earnest money, who gets the earnest money. All right. The broker that's holding the earnest money can send a letter to both parties, certified letter, that says that unless litigation is started within 60 days, the broker will determine who gets the earnest money. That's holding the earnest money. That puts the pressure on the buyer and seller, one or the other, to get the litigation going. They can't just sit out there and not do anything. That option is not available to a title company. So if a title company is holding the earnest money, they don't have the option of sending a 60-day letter. The earnest money remains in limbo until buyer and seller agree what to do. So that's the basic change there. They're just adding language in there, letting the buyer know that if the title company's holding the insurance or the earnest money, then this part up here, which talks about the initiating litigation within 60 days, that is not applicable if the title company is holding the earnest money.
I see a lot more with title companies holding the earnest money now rather than the seller's broker.
Well, I do too. And part of the reason for that is because there's a lot of brokerages out there that don't have their own trust account.
Oh,
And because they don't have their own trust account, then they have the title company hold it. I don't think it's a good practice, but I mean, title companies are generally honest, but they do not have access to the 60-day letter. So again, there are a lot of title companies holding earnest money, and there's a lot of brokers out there that require that the title company holds the earnest money. You just need to make sure you advise your buyer accordingly. And this language is put in here so that later on, if the buyer's reading through this and says, hey, can't you send a letter and get the earnest money for me? No, you can't, because I don't hold the earnest money. The earnest money is being held by the title company, and they can't send that letter. So it just makes sure that you're not on the hook trying to fulfill language in the purchase agreement that can't be fulfilled. So that's why that was added in there. Only a real estate licensee is holding the earnest money can send the 60-day letter if the transaction doesn't close. So any other questions on that? Okay.
So, yeah, I'm sorry.
Okay.
So the title company cannot hold the earnest money anymore?
Oh, yes, the title company can hold it. They cannot issue a 60-day letter if it doesn't close. They
Okay,
can
any
hold
of the
the
realtors can do.
realtors, if a broker, a licensee is holding the earnest money, the licensee that's holding the earnest money can send the 60-day letter. A title company cannot. So if the title company's holding the earnest money, they can't send the 60-day letter. That's all that's saying.
Jim, is that because the title companies, according to you, the last time I heard, is that they are not regulated? They don't have the same regulations as the realtors or.
That's correct. They're not a licensed real estate agent, and they're not a member of the National Association of Realtors, so they have no code of ethics that they have to fulfill. They have no licensing requirements that they have to fulfill as far as what real estate licensees have and brokerages have. So in terms of their handling of earnest money, they are under different, they're not under the same requirements that we are as brokers. Okay, continuing on, line 138 through 143 on the purchase agreement, they added a whole big section in here. leased property. So if this property is subject to an enforceable lease between seller and tenants, such lease will be provided to buyer by seller within X number of days after acceptance of this agreement. If buyer does not make a written response to the lease within X number of days after receipt, the lease shall be deemed acceptable. Possession will be subject to tenant's rights. In the event the buyer does not accept any provisions of the lease and such provisions cannot be renegotiated with tenants, this agreement may be terminated by the buyer and the earnest money deposit shall be refunded to buyer promptly. So this is, if you're representing a buyer of an investment property, there's already a tenant in place with a lease in place. Then this gives the buyer the out if they see the lease and they decide that the terms of that lease are not acceptable to them, and therefore they don't want to buy the property and have to be bound by the terms and conditions of the lease that the previous owner had with tenants. This could also be the case of where even an owner-occupied buyer where there's a tenant in place, they want to see the lease to make sure that they don't have to honor the lease and that the tenant would have to move out. So again, if it's a leased property with a tenant in place, that's what this section is all about.
Does it have a time? So, say the whole thing is accepted, at what point should the seller provide the lease, and to what point the buyer can get out of it?
Yeah, X number of days. Okay, so
Oh,
for
yeah,
instance,
that's right. Yes, I'm sorry.
yeah, you fill in the blank. So you could make it within 1 day, you could make it within 3 days, you could make it within 7 days, that they supply the lease. And then there's an additional response period after that for the buyer to make a response. So it's just like HOA docs, only now they're doing it for a lease. So they have to provide the lease within a certain period of time. The buyer has a certain period of time to respond. If there's no response, then it moves on toward closing. Survey, they just added a little section here. It's on line 148 and ordered by buyer, seller, and other. It just clarifies who's going to order the survey. And usually the survey is going to be ordered by the title company. So you would just check the box other and title company. Or if the buyer is going to order their own survey, then you would check that, and it's up to the buyer to order the survey. Or if you check seller, then it's up to the seller to order the survey. So that is something, though, that you want to pay attention to when you receive a purchase agreement on your listing. Take a look there and see who's supposed to order the survey, because it may be that your seller has to order the survey, in which case you can't rely on the title company to do it. You need to have your seller do it. So just be aware that change has happened, and don't get caught by that unawares. Then on line 194 in the purchase agreement, it's talking about waiving the right to have independent inspections, and inspections required by law, FHA, VA, or by lender are not included in this waiver. So in other words, if the VA requires, or FHA, which they do, they require an inspection by the appraiser, those inspections cannot be waived because they're required by the lender. So at any rate, that's just clarifying that language so that the seller can't come back later on and say, well, a buyer waived the right to have independent inspections. I don't need to do any of these repairs that the FHA say that I have to do. You know, and I have to fix this peeling paint because they signed a waiver. That's not the case. They have to do what the FHA, the waiver doesn't apply to those circumstances. So that's just clarifying it so that you're not caught in that circumstance. And then down here, seller inspection or seller response to an inspection defect. It goes through the language of sellers unable or unwilling to remedy the defects, et cetera, et cetera, et cetera. And then down here, it says seller may terminate this agreement by submitting a mutual release. So it just clarifies that that's the document that they would use to terminate an agreement based on an inspection response. So it's just clarifying what document to use. Then there's one kind of obscure one in here. It's right here. It's item number 8, line number 3, 88 and 89. And up here, it says this agreement shall be construed under and in accordance with the laws of the state of Indiana and is binding upon the parties' respective heirs, executors, administrators, legal representatives, successors, and assigns. Buyer may not assign this agreement without the consent of the seller. So basically that means that if this agreement is being assigned to somebody else, the seller has to agree to that. It can't just, the buyer can't unilaterally assign the agreement to somebody else. The seller has to agree. That makes sense?
Yeah.
And I think that's it for the purchase agreement. Okay, now go to the buyer's exclusive agency agreement.
Oh, did that change?
Bad I can't have all these forms open at once. Okay, this is the buyer exclusive agency contract. And what they've added here is this little line right here on 6 and 7. And it just says that this contract shall automatically extend to coincide with the closing date if it does not take place until after the term of this contract. And that's just to make sure that you don't have to do an amendment to this to extend the length of the buyer agreement. Once you've entered into a purchase agreement, it will extend automatically beyond the expiration of this agreement. So just make your life a little easier. And then down here, they've added quite a bit down in here.
Oh.
So from lines 42 down through basically 66, they've added all this language. A licensee representing a buyer has the following duties and obligations. So they've just spelled these things out. 1, to fulfill the terms of the agency relationship made with the buyer, to disclose the nature of the agency relationship with the buyer and redefine and disclose if the relationship changes. To promote the interests of the buyer by A, seeking a property with a price or lease rate and contract terms satisfactory to the buyer. However, the licensee is not obligated to locate other properties to purchase while the buyer is under contract to buy a property unless otherwise agreed between the parties. B, presenting all offers to purchase to and from the buyer immediately upon receipt of an offer, regardless of whether the buyer is already under contract to buy property unless otherwise directed by the buyer. C, disclosing to the buyer adverse material facts or risks actually known by the licensee concerning the real estate transaction. D, advising the buyer to obtain expert advice concerning material matters that are beyond the licensee's expertise, such as square footage. Is one of those. Also, also surveys, also tax ramifications, also inspection issues. We're not home inspectors, so it's just saying that they should get expert advice. E, timely accounting for all money and property received from the buyer. F, exercising reasonable care and skill. And G, complying with the requirements of this chapter and all applicable federal, state, and local laws, rules, and regulations, including fair housing, civil rights, statutes, rules, and regulations. Licensee owes duties of trust, loyalty, confidentiality, accounting, and disclosure to the buyer. The duties of accounting and confidentiality extend beyond the agency relationship unless disclosure of confidential information is required by law, becomes public, or the client gives written consent to disclose. A licensee representing a buyer owes no duties or obligations to the seller, except that a licensee shall treat all prospective sellers honestly and not knowingly give them false information. So it's just clarifying basically who's representing who in the real estate transaction and what the requirements are of you as a licensee who's representing a buyer, what your requirements are towards that buyer as far as representing them. And so this has all been added to your buyer agency agreement. And then down here you have fair housing section that has been added. It just basically says parties acknowledge that the Fair Housing Act prohibits discrimination in housing because of race, color, national origin, religion, sex, familial status, and disability. And then it goes on to say down here, the National Association of Realtors Code of Ethics also prohibits realtors, which is us, from discriminating on the basis of sexual orientation or gender identity. So there's two additional protections that come under the category of fair housing that are protections forwarded by the National Association of Realtors, not the Fair Housing Act. So it would determine whether it's a code of ethics violation or a violation of the law. So the Fair Housing Act would be a violation of the law. Whereas the two situations determine the code of ethics would just be a code of ethics violation, not a violation of the law. So it just adds that in there. And then there's a legal disclaimer that has been added. And it goes through the same information. Buyer acknowledged that the broker is not a professional or expert in matters of law, financing, taxes, property conditions, and/or inspections. In addition, the broker is advised and recommended buyer seek expert assistance for advice on such matters. Broker makes no warranty or guarantee concerning the service of such experts or their products, the condition of the property, the absence of defects therein, or the ability of such property for buyer's purposes. One of the things that's very important to keep in mind here, frequently on a real estate transaction, you will see a listing where the buyer is required to sign a required addendum or some other document. This happens a lot with relocation properties where buyer has to sign a relocation agreement. These agreements are never for the benefit of the buyer. They are always for the benefit of the seller or the seller's relocation company. But you cannot advise them on those documents at all. They have to advise themselves on those documents or seek legal counsel. So whenever faced with those documents. You just need to tell them, I am not licensed to practice law. I cannot interpret that document for you. You will have to read it on your own and seek legal counsel to interpret that document. I cannot do it for you. So don't get caught in the unlicensed practice of law where you read through an addendum and you try to tell them what it means. You just can't do that because you're not licensed as an attorney. Then it's been added in here that attorney's fees, that litigation to this contract, who pays attorney's fees. That's part of just about every contract, and this is a contract. And then there's a big section in there about wire fraud. That's become part of just about all of our documents. It's in the purchase agreement, it's in the, so it's just something that is a disclaimer, basically, admonishing the buyer to be aware of the threat of wire fraud and steps to take to avoid it. So that is part of the buyer's exclusive agency agreement. Any questions on those changes?
I was reading what that says on the fraud, wire fraud, and that says, do not rely on any phone number on the email.
Yeah, right.
Well, they said, they tell the broker, the realtor, tell the buyer to call the company, the title company, to verify that. So what
Yeah.
number they should call? Usually it's coming by email, or you go to Google and check it. So
Yeah, you have to look up the title company and hope that you're actually on the title company website to get their phone number. Yeah. Kind of crazy. But I mean, these the people, these fraudsters are real, and
yeah.
and they have been successful doing what they do. The listing contract just has some very minor changes to it. I think we'll run through it real quick. We're really over time, but I want to try to get at least through the listing contract. Just some minor changes here, not near as many changes as were on the purchase agreement. So not as much to worry about with listings. They added this right here, down here, where it's property offered for sale and what's included. And sellers shall provide any and all access codes, passwords, or any other information required to operate such devices if included. So, and that's talking about these smart devices and controls and those kinds of things. So any codes that they might need, like the garage code or whatever, the seller is agreeing to provide those. And so you just need to make sure that you get all of that information from your seller when you're doing the listing. And then there's a change to the agency disclosure here on line 149 through 151 of the purchase agreement. It talks about confidentiality extend beyond the agency relationship unless disclosure of confidential information is required. Whoa, what happened here? Dang. Okay, I had a thing pop in there. What the heck? Okay. All right, so and then I think there's one more change in here. No, maybe not. Maybe that's it. Yeah, that's pretty much it. Okay, so That's pretty much it on the listing contract. Any questions on that, those items? There were also some new forms added, and we'll just, they're pretty simple forms, so I'll take a little extra time and go through those. One is a hazardous property condition disclosure. This is just a form put together by IAR to, so that if there is a hazardous situation in a property and you need to, like COVID or whatever it might be, you can get this disclosure signed before people go through the property. There's a homeowners association disclosure. This is kind of an interesting form because now it's documenting that these documents have actually been received by the buyer. There's signatures required on this document for both buyers and sellers. So you need to pay attention to this one because it has a bearing on your purchase agreement. If I can get this open. Okay, so homeowners association disclosure form. And down here, it's got all your homeowners association information. And down here, this yellow, brokers are not responsible for obtaining, verifying, or interpreting this information. The parties agree that brokers and their companies shall be released and held harmless from any and all liability arising out of or related to the disclosure of any homeowners association information or documentation. Seller, by signing below, affirms that the above information is true and accurate to the best of the seller's knowledge. Buyer, by signing below, confirms that a copy of the recorded governing documents has been provided and the above information has been received. So both seller and buyer are signing this, and it represents what each one knows. And it also makes clear that we're not the ones that determine that. Again, that would put us into the unlicensed practice of law to try to determine what a HOA document actually says.
Is that a new document? Can you scroll it down to see the name?
This is a new document. Yes, this is the
Oh, okay.
Homeowners Association disclosure form. Okay, so this is a form. I think the way that you would probably use this is when you list the property, you would fill this form out and get your seller's signature. Then when you sell the house, you would send this form along with the HOA documents to the buyer for the buyer to sign acknowledgement that they've received this information.
That says broker are not responsible for obtaining. I had a case. Did we close? We haven't closed yet. And they sent me the homeowner documentation. And when I saw it, I said, this is not complete. So that put you in a situation because the listing agent says, my seller provide them to me. And I say, I understand that, but I don't believe they're complete because they're very short. And usually those, how you call them, the documents are very long. Sometimes they're 48 pages or whatever. And
Yeah.
finally we find out there were more. So.
Yeah, I mean, from a buyer agency perspective, you can go to title company websites and look up the documents there. So you can help your buyer that way. Maybe there's a complete set of documents there. You could also reach out to the homeowners association and request a copy of those documents. Don't be surprised if they charge you a fee for that. That's why you want to put the pressure on the seller to do that. But this is saying that we're not liable for those documents, and we're not liable for determining what's going on with those documents. It's not something that we have to determine. Okay. Make sense?
Yes.
Let's see, there's also, I knew this would be a lengthy, I hate to keep you guys. Oh, there's no buyer agency relationship. I think this is in a response to the lawsuits. And that's where, as a listing agent, you may be approached by an unrepresented buyer who does not want a buyer's agency. And they also do not want to be represented as a limited agent. They just want to represent themselves. This is a form for them to sign saying that the buyer is not being represented in this transaction by a real estate licensee. Buyer does not consent to limited agency. Therefore, parties agree listing broker is only representing the seller's interests.
We don't
To
see the
make it
document. I
clear-
see the word Zoom, but we don't see the document.
Why?
The document is not there.
I see it.
You see it? I don't see it.
Yeah.
Right here.
Not a lot of words on the document.
Where? I see the word Zoom. That's it.
No buyer agency relationship acknowledgement. You don't see that?
Uh-uh.
I can see it.
Okay.
Yeah, I can see it too.
It's my part. It's me.
Might be your internet connection or something. I don't know. But at any rate, you need to get that signed. And again, because of some of the changes that are going on a national basis, you may start having buyers approach you as a listing agent wanting to buy one of your listings, but they don't want to be represented.
Yeah, I just had a commercial lender do that. I would use this document for sure.
Yeah.
He's going just direct to the listing agents because he thinks he knows the game. So he's like, hey, I want to make an offer and I don't want the 3% or 2.5% to cost me.
Yeah. Yep. So get them to sign this so that it is clear you're not representing them and that you are representing the seller. So just a new form that they've added. So that's the use for it though, is when you're the list agent and a buyer and you're involved in a transaction with a buyer that does not want to be represented. There's also an amendment and an addendum to the exclusive buyer agency agreement. Those are just amendments and addendums if you have to change something or add something. So those are just blank documents like every amendment and addendum. They just added those so that you could amend and addend the buyer agency agreement. Okay, that's it. Any other questions before we end the call?
Ma'am, I have a quick question. If we do start seeing buyers just representing themselves, what form will they be used?